Welcome to the Remedies video lecture series. This is lecture number 10, and this lecture will discuss restitution. This lecture is designed to discuss the materials that we will cover in class, both this coming Wednesday and the following Wednesday. This lecture covers all of the materials on restitution. Let's begin. Restitution is both a cause of action and a remedy. As you will see as we go through the materials, it is used as an alternative at times to other available remedies because it either covers issues that could not be dealt with by the other remedies or provides greater remedial relief to the plaintiff. Restitution, although it originated in equity, now supports claims at law and in equity. You'll see how this plays out as the cases will discuss claims both in law and in equity. The underlying premise for restitution is the concept of unjust enrichment, that the defendant has obtained a benefit that in justice they should not retain. And you'll again see how this plays out in the various cases. The remedy for restitution is the benefit to the defendant, not the loss or damage to the plaintiff. The remedy is measured in what the defendant gained, not what the plaintiff lost or how the plaintiff was damaged. This is very different than our contracts or tort remedies that we have been looking at. With restitution, there's generally two questions that courts will ask. Was the defendant unjustly enriched? And we'll again see how this plays out. And what was the benefit to the defendant? As I said earlier, just immediately, this is the measure of what the remedy is. Now let's look at claims at law. With claims at law, as we know, the plaintiff has the right to a jury trial. These are claims that are legal claims, and they derive in restitution essentially from contracts that are implied in law and are supported by a claim of quantum meruit. They are also supported by waiver of the tort of generally the tort of conversion, and the plaintiff brings suit in what is known as a sumsit. And again, I'll explain more of this as we go along. Claims in equity, in contrast, there is no right to a jury trial, and the normal equity requirements and defenses apply to these claims. And the basics for the cause of action when there is a claim in equity is usually a breach of fiduciary duty or trust, and they're supported by the equitable remedies of constructive trust or equitable lien. We will go through all of these throughout this video. Let's start talking about contracts implied in law. Remember, these are legal remedies. These are causes of action at law. Now, contracts implied at law are distinct from contracts implied in fact. Contracts implied in fact are actual contracts. Although the parties may not have explicitly agreed to the contract, a contract implied in fact is derived from the facts underlying an agreement between the parties. A contract implied in law is merely a legal fiction. There is no real contract between the two of them. The courts have created this contract implied in law to find a way to grant plaintiff relief under the concept of unjust enrichment. As I said, it is a complete legal fiction. There is no real contract, or for some reason an actual contract between the parties is defective. It is an obligation imposed by law to do justice, and again, this is where I said that it is drawn over from law from equity. Normally we would see obligations imposed to do justice imposed by courts of equity. Well, in this instance, the common law courts picked up this remedy and have developed it under this concept of contracts implied in law. And the essence of the obligation is the receipt of a benefit which would be inequitable for the party to retain without paying for it. Again, you see the equitable nature to do justice in this remedy. Let's talk about some examples of how this occurs. Well, the courts are going to find contracts implied in law when services are provided that normally would be paid for and were not intended to be gratuitous. And you see this playing out in the case of Matter of the Estate of Zent, where the woman provides health care and end-of-life care for an elderly gentleman and then sues the estate later to be compensated. And the court finds that in order to do justice, it's going to find a contract implied in law and grant her restitution for what she is seeking. Another instance where courts will find contracts implied in law in order to do justice are where the actual contract is not valid. Again, we saw this in Payet versus Payet, where the court said that the terms between the parties, a husband and wife, were too indefinite to find a real contract. Or in Campbell versus Tennessee Valley Authority, where the court found that the the dog was barking in the background, where the court found that the party contracting on behalf of Tennessee Valley Authority did not have the authority to enter into the contract, that it was beyond his agency authority, and therefore there wasn't a valid contract. In both of these instances, although there was thought to be a contract, the courts have found it to be invalid and permitted the parties to proceed on a claim of restitution based on contracts implied in law. Another instance where this occurs, and where you see it in your cases, is where the contract fails to address an issue. And then you see this in this QHC case, where the doctor's contract did not cover various aspects of his employment duties. It failed to address time off and various other issues, and the court then relied on concepts of restitution and contracts implied in law to find an obligation to compensate the plaintiff in that case, so that the plaintiff would not go uncompensated for work that was performed. And finally, there are instances where the plaintiff waives suit in contract and proceeds in restitution. And you see this in this Monarch Accounting case, the case where the landlord erected a billboard on property that the landlord had leased to a tenant and had no right to erect the billboard. The other instance where restitution is used at law is where there is a waiver of tort and suit in what is known as a sumpsit. And this transforms the tort suit into a claim of contract, because again, you'll see the courts are relying on this concept of implied in law contracts, and they treat those cases as contract cases, and this can have significant benefits to the plaintiff when they proceed in this matter. This is known as, when they do so, indebitus, I can't really pronounce it, assumpsit. It's based on a fiction of creating a quasi-contract between the plaintiff and the defendant. It's based on conduct of the defendant in obtaining property or benefits that they should not justly retain. You see this most often in conversion cases, where the defendant has converted property that is rightfully the plaintiff's, and for whatever reason the plaintiff has chosen to waive the tort of conversion and to proceed with suit in assumpsit. And you'll see some examples where this occurs in our cases. Now, indebitus assumpsit creates quasi-contract writs, and you'll see these play out. There are two writs that have been created in order to create this quasi-contract. One is the writ of money had and received, And this is purely a fiction, that the defendant who converts property of another and then sells that or retains that, the measure for that one where the defendant sells the property, the fiction is created as if the defendant were acting as an agent of the plaintiff, and the courts will find the measure of the damage there, the amount the defendant received for the goods. So when the defendant converts goods and then sells them, this writ of money had and received is going to provide the plaintiff with relief if they do not wish to sue in the tort of conversion. The second writ that occurs here is the writ of goods sold and delivered. This writ is where the defendant has converted goods and retains them, does not sell them. Excuse me. And the measure here is the fair market value of the goods. And this is where, as if the plaintiff had agreed to sell the goods to the defendant for their fair market value, and the courts in this instance will award the plaintiff the value, the fair market value of the goods when the plaintiff waives the tort of conversion and proceeds with their suit in a subset based on the writ of goods sold and delivered. And now, why would one bring an action in restitution, a legal action in restitution? Well, there's a number of reasons, and most often restitution is brought as an alternative claim. So they would bring their suit in contract, and in the alternative they would bring their claim for restitution. And the reason for doing so is if the suit in contract fails, then they will be able to still obtain relief in restitution if they can make out the elements in this action. Likewise, they will bring suit, they may bring a suit for the tort of conversion, or waive that tort and bring a suit in a subset, because the results will be more favorable to the plaintiff. We know that the relief in a suit in conversion is essentially the fair market value of the property converted at the time of the conversion, or when the plaintiff obtains notice of the conversion. Well, restitution may provide this tort plaintiff with far greater relief than they would have obtained, because if the defendant has taken the property, converted it, and sold it in excess of the fair market value, the plaintiff may be able to recoup this. Or if the property has appreciated significantly since the plaintiff learned of the conversion, the plaintiff may be able to get their appreciated property back. So, number of reasons you do this, as I said, were contract problems, an invalid contract, or no contract at all. And we saw this play out in a variety of cases here that all looked like they were contract cases, but for one reason or another, the contracts proved to be invalid or defective for a variety of reasons. Also, they are brought, as I said, where the contract or tort damages are too low. Excuse me. And you see this playing out in a number of these cases where the plaintiff was able to obtain far greater relief by bringing their action or bringing a claim in restitution. Finally, there are instances where the statute of limitations in tort has expired, and there will be a longer statute of limitations in contract. And we see this specifically in this H. Russell Taylor's Fire Prevention Service case. In that instance, the court found that the suit in restitution, by waiving the tort of conversion and bringing a suit in restitution under the writ of a subset, the plaintiff was able to bring their suit under the contract statute of limitations, which I believe in that case was 4 years instead of the shorter tort statute of limitations, thereby surviving a statute of limitations problem. Let's talk about now how claims in equity are brought, because as I said earlier, restitution is both an action in law and inequity. So claims in equity will lead to the relief of obtaining a constructive trust or an equitable lien. And both of these remedies have significant benefits to the plaintiff. Now these are both equitable remedies that must be premised on the same legal grounds. The premise is the same and must conform to the requirements of equity and the limitations of equity. The first of these, as we've seen before, is the plaintiff must demonstrate that there is no adequate remedy at law. And the cause of action in restitution in equity is generally based on actual or constructive fraud, or an abuse of a confidential or fiduciary relationship. And you see both of these being used in the various cases, equity cases, that are in the book. So let's go on and talk about this. The plaintiff first must demonstrate that there is no adequate remedy at law in order to bring their restitution claim in equity and to have available to them the remedy of constructive trust or equitable lien. And you see no remedy at law easily playing out in County of Cook versus Barrett. There was no action at law to bring against the county official who was taking bribes. The best action that the plaintiffs could come up with was claim in restitution in equity that the county official, Barrett, who was obtaining the bribes, was unjustly enriched as a result, and in reality that money should go back to the county. The county should get the benefit of Barrett's fraudulent or conduct that breached his fiduciary duties to his clients, the primary employers of the County of Cook. You also see it where the remedy at law is not substantially equivalent to the equitable remedy. This plays out where one of the parties, the defendant, obviously, may be insolvent, so that although there is a remedy at law, it will not gain the plaintiff anything because the defendant is insolvent, and there are other creditors who will take far ahead of the plaintiff if they bring their action at law. And as we'll see in a minute, the equitable remedies of constructive trust and equitable liens will give the plaintiff an advantage over many creditors. So if the defendant is insolvent, there may not be an adequate remedy at law, or if the property that the plaintiff is seeking to attach the constructive trust to or the equitable lien is mortgaged, it too will disadvantage the plaintiff if they bring their case at law. So in various instances, the courts will find that there is not an adequate remedy at law when it is not substantially equivalent to the equitable remedy, where it won't give the plaintiff the same or very similar relief. Now, the actual and constructive fraud is one of the requirements of proving restitution at equity. They must prove actual or constructive fraud in playing out, and you see this playing out in these various cases that we've had to read for the equitable section here. And you see it where the husband conveyed an interest in the home to his wife through fraud, where he was bullied into doing this. The courts are going to find that there was actual or constructive fraud. Or where the parents of the plaintiff lied about paying back the loan that she had provided them. Again, the courts are going to find an actual or constructive fraud. Or the final time where we see this in the cases is where the plaintiff has provided benefits to the defendant, improved property that the defendant accepted knowing that the improvements were being made without them intending to pay for the improvement. The courts again in that instance found an actual or constructive fraud, and therefore supported the claim of restitution by the plaintiff. The other instance where the other requirement, or as an alternative requirement, is an abuse of a confidential or fiduciary relationship. This is played out most explicitly in this County of Cook versus Barrett, where Barrett takes bribes from various contractors contracting with the county, and the county then sues Barrett to retain the funds that Barrett had been given in these bribes, finding that he had abused his confidential or fiduciary relationship that he owed to the county in not taking the bribes and not awarding the contracts to those who were bribing him. That's an explicit case, and you can see how it plays out in that case. Now let's talk about constructive trust for a minute. Constructive trusts create a duty on the constructive trustee, which is usually the defendant, to convey title to the plaintiff. It is again a legal fiction, and because the defendant really isn't a trustee, but what it does is it gives the plaintiff equitable title in the property, and it is, in many instances it operates automatically. It's self-executing. The defendant is now said to have conveyed the property back to the plaintiff, and the plaintiff holds it in trust, and it now has title to the property. And it applies generally to property that can be divided or conveyed in whole. And you'll see this playing out later in a minute when I talk about equitable liens. But it only applies to property that the plaintiff can get either a piece of, which can be subdivided in some way, or property that can be conveyed in whole. And it applies to real property, intangible property, and liquid assets such as stocks, bank and investment accounts, insurance policies, money, will be one, cash, or money in accounts. And it is a better remedy at times if the property has appreciated. So if the property has increased in value, it is an advantageous remedy for the plaintiff, because the plaintiff gets the property. They actually obtain that property. So if the defendant stole $25,000 and bought diamonds with the $25,000, and the plaintiff seeks a constructive trust over those diamonds, and in the meantime those diamonds are now worth $35,000 or $45,000 or $55,000, and the plaintiff prevails, the plaintiff actually gets those diamonds, which now have an increased value. Let's talk about equitable liens for a minute. These are very different than a constructive trust. This provides the plaintiff with a security interest in the property to the extent of the judgment that has been granted them. This doesn't give the plaintiff the actual property. It's just a security interest that the plaintiff will have in the property, and it applies if the defendant or others have a legitimate interest in part of non-divisible property. And the best way to think of this is if the defendant has stolen $25,000, takes that $25,000 and makes improvements to the defendant's home that the defendant legitimately owns, and now the plaintiff seeks to recoup their $25,000, the plaintiff is going to obtain an equitable lien over the home, and may have rights and benefits as a result of that ahead of other creditors. An equitable lien is not self-executing. The property must be foreclosed upon to obtain the money. That is, the plaintiff must go back into court and make out an equitable claim in foreclosure in order to obtain their money. So there's another opportunity for a court in this instance to deny relief if the defendant can make out a claim for denying relief. This does provide, though, a security interest that is often superior to many other creditors. So this will provide an equitable lien for the plaintiff that will prevail ahead of many other creditors when it comes time to foreclose upon the property that the lien pertains to. So you can see that it would be advantageous if the defendant is insolvent and other creditors are seeking to obtain assets of the defendants. And in contrast to a constructive trust, which is a better remedy when the property has appreciated, this is a better remedy when the property has depreciated, because the lien will apply to the property, but if the property is worth less than the lien, this does not prevent the plaintiff, if they have a way of doing so, from still recouping a remainder of the amount owed by the defendant. The defendant still owes this to the plaintiff in either instance. So the plaintiff doesn't get the actual property, so if it's depreciated and they were to get the actual property, they would obtain less than their judgment. This is only a lien on the property for that amount, and once the lien is executed, the remainder of the judgment still exists, and the defendant would owe it to the plaintiff. Okay, and this applies to all property that can be traced to benefits improperly obtained by the defendant. Tracing allows an equitable claim for constructive trust or an equitable lien to follow through various transactions and to obtain a trust or a lien on the property. And we'll see it playing out in the various cases. This permits tracing of money or other assets into mixed accounts. And this you can see, for example, if the defendant converts $25,000 that rightfully belongs to the plaintiff and places it into a savings account that the defendant has already placed another $50,000 into previous to the conversion, now the money in the account is $75,000. And the problems that the courts face is to figure out which of that money, $75,000, belongs to the plaintiff and which of it is rightfully the defendant's, especially now if the defendant starts to spend some of it. So the defendant withdraws $10,000 and buys gold with that $10,000, and that gold now appreciates to $20,000. Now through tracing, if the plaintiff can trace that $10,000 as their assets, as their funds that are rightfully due them, they would be able to obtain a constructive trust over the gold and actually obtain $20,000 in gold that would represent their property and obtain greater relief than they normally would have had. Now there are multiple tracing rules that the jurisdictions use. Essentially there are 5 rules that are applied in various jurisdictions today. These rules, as I said, are purely fictions created to decide when mixed funds or mixed property are blended, how to determine which property or funds rightfully belong to the plaintiff and which rightfully belong to the defendant. As we go through and see, you'll see how the various rules apply, but remember, these are purely fictions, and you would have to see which jurisdiction you are in as to which rules that jurisdiction applies to the tracing of property. Let's take a look at these different rules. The first rule is known as the first in, first out rule, or the rule in Clayton's case, and this merely states that the first funds into the account are assumed to be the first funds that leave the account. So if initially the defendant had money of their own in the account, $50,000 let's say, and they converted $25,000 of the plaintiff's, put that into the account now, and then withdrew $10,000 to buy the diamonds. Under this rule, the first funds in the account were the defendants, therefore the first funds out of the account would be the defendants, and those diamonds would rightfully belong to the defendant, and the plaintiff could not obtain a constructive trust or an equitable lien over the diamonds. The second rule is known as the Jessel's bag rule. This rule states that the first funds withdrawn from the account are presumed to be the defendant's, regardless of whose funds went into the account first, and the remaining funds are subject to equitable claims. So again, in our instance where the defendant had 50 grand in the account, embezzled or converted 25,000, placed that into the account, now withdrew out funds and bought the diamonds, those diamonds would be the defendants, because the first funds out would still are presumed to be the defendant's money. Because of sometimes the unfairness of this rule, the courts in a case in re Otway modified the rule to allow the plaintiff to choose to trace assets withdrawn first or those withdrawn later. This gives the plaintiff the option to say that the first funds out will be mine, regardless of whose money went in first, or the money withdrawn later will be mine. Because if the defendant, instead of buying diamonds with the first 10,000 that they withdraw, spends it, wastes it, gambles it away so that there's nothing to show for it, well, clearly in that instance the plaintiff doesn't want the first funds out to be theirs. They want that to be the defendant's legitimate funds, and they'll be glad to take money later, or to trace assets that are later withdrawn from the account. The fourth presumption that was created under the restatement second is that the plaintiff may recover proportionately those funds that represent his portion of commingled funds. So in my example, as I stated before, where the plaintiff where the defendant had 50,000 in the account and converted 25 of the plaintiff's money, well, then in that instance 2/3 of the funds would be deemed to be the defendant's and 1/3 would be the plaintiff's on all subsequent withdrawals from the account, or whatever is left in the account. So if all 75,000 stayed in the account, the plaintiff would recover 1/3 their 25,000. But now if the defendant initially withdrew 10,000, well, 2/3 of that would be the defendant's money, and 1/3 of that would now be the plaintiff's money, regardless of what happened to that 10,000. If it's wasted away, well, 1/3 of the plaintiff's money has now been wasted away. If diamonds are bought and they appreciate to 20,000, the plaintiff could attach a lien or a constructive trust on those diamonds for 1/3 of the 20,000, and 2/3 of the 20,000 would belong to the defendant. Now, the fifth and final rule was just created fairly recently with the restatement of Restitution third. This rule creates a dual presumption. Withdrawals that are untraceable or unprofitable are allocated to the wrongdoer. So when you can't figure out what's happening, or where they're unprofitable, he's wasted away, those can be attributed to generally the wrongdoer, which is usually the defendant. And the plaintiff, the second presumption here is the plaintiff can elect tracing on the remaining funds where it is favorable to the plaintiff. So these are the 5 tracing rules that allows the plaintiff to follow money, follow property through various transactions and obtain a constructive trust or lien on this property down the line. And there is a major limitation, though, on the plaintiff's ability to do this. And this comes into play with a bona fide purchaser for value. A bona fide purchaser for value who takes the property without notice of the equitable interest and obtains legal title defeats the equitable claim to the property. So if the defendant has sold the property legitimately to a buyer who has paid for the property, given value, and has no notice of the equitable claims of the plaintiff, the plaintiff will not be able to further trace that property down the line. An example of this, with the diamonds, the defendant has taken $10,000 of the $25,000 that they've converted, bought the diamonds, and now later sells those diamonds to someone who pays them the $20,000 for those diamonds and has no notice of the equitable interest, the plaintiff will not be able to trace and obtain a constructive trust or equitable lien over those diamonds. They may be able to obtain and trace and obtain an equitable lien or constructive trust over the proceeds from the sale of the diamonds, but they will not be able to get the diamonds. And these equitable claims will prevail even over innocent parties who have obtained the property, again, unless they are a bona fide purchaser for value. So if the defendant has given the diamonds to someone as a gift, they will not be considered a bona fide purchaser for value, and the plaintiff will be able to bring an action against the recipient of the gift and prevail and obtain a constructive trust or equitable lien over those diamonds, even though the defendant legitimately gave them as a gift, because the subsequent holder, the one who got the gift, is not considered a bona fide purchaser for value. This brings this video session to an end. Thank you for being patient. This was a very long video session. As usual, you need to go to the Twin site and fill out the assessment for video lecture number 10. This will now bring these video lectures to an end, and thank you for being patient with me and the various mistakes that I've made as I've gone through the videos, the pauses, the coughs, the dog in the background barking. I hope you have gained from these. Thank you.